So welcome to everybody. A very warm welcome to the first LSE-UCL Law Finance Seminar in the summer term. And we have a fantastic lineup of speakers and discussants this time again. We have a joint presentation by two professors from the University of Glasgow, by Irene-Marie Esser and Iain MacNeil. Let me briefly introduce them and then also introduce our two discussants. Irene-Marie is Professor of Corporate Law and Governance at the University of Glasgow. She's an expert in corporate governance, company law, corporate social responsibility. Before joining Glasgow, she was at the University of South Africa, I believe, and she also still is an extraordinary professor at Stellenbosch University, also in South Africa. She's worked widely. She's both published widely on issues of corporate governance, corporate social responsibility, but also has been involved in policy work in that space. She's been a consultant to the King IV Committee on Corporate Governance in South Africa, and she's a member of the United Nations Principles for Responsible Investment Academic Forum, to name just some of her activities. And Iain MacNeil is Alexander Stone Chair of Commercial Law at the University of Glasgow. He's also published widely on corporate governance, financial regulation. He actually used to work as a financial analyst, as an investment analyst in the City of London before joining academia. He was first in, when he took the academic route, he was first in Aberdeen, I believe, and then joined the University of Glasgow. And he's also been involved in policy work. He's been a special advisor to the House of Lords EU Committee on some questions regarding MiFID II, and a senior advisor to the Director General for Financial Stability, Financial Services, Capital Markets Union, FISMA, of the European Commission. So Iain and Irene-Marie will present jointly, and then their presentation will be followed by the interventions of, as we always do it, by the interventions of two discussants, Stefan Park and then Eva Micheler. Stefan Park is Associate Professor and Sattell Fellow in Corporate Social Responsibility at the University of Connecticut School of Business. And he's really, I can't think of anyone who would represent the interdisciplinary spirit of our seminar series better than Stefan, because he holds a JD from Harvard Law School, a master's in international affairs from Tufts University, and a BA in ethics, politics, and economics from Yale. So he covers, I would think he will cover corporate social responsibility and the topic of today's talk from every possible disciplinary angle. So thank you very much for agreeing to join this seminar. Stefan, I should just also briefly add, Stefan's work concerns international financial regulation, corporate social responsibility, and accountability. And he currently focuses in particular on aspects of ESG investing and sustainable finance. So really a perfect match, I would think, for today's talk. And last but not least, Eva Micheler is an associate professor of law at the London School of Economics and also extraordinary professor at the University of Economics in Vienna, I think, still. And she has also published widely on different aspects of corporate law, and her work has been cited by, among other courts, by the UK Supreme Court and the Austrian Supreme Court. She's also been involved in policy work. She's a member of the Investor Protection Intermediary Standing Committee at ESMA, and has been an advisor to the UK government on questions regarding intermediated shareholdings. So that shall suffice in terms of introduction. Hope I didn't miss anything of importance from your long CVs, and I hand over to Irene-Marie now. Thanks very much.
Thank you, and thank you so much, Carsten, for that kind introduction, and also for the invitation to present here today. We look forward to share our work with you, and also to the feedback and comments from the two discussants. But without further ado, let's start with our presentation. And just to give you a brief outline of what we will focus on today, I will start by giving a brief introduction, focusing on the origins and development of ESG investing, and specifically looking at the move from CSR to ESG via sustainability, and then give a bit of background or our interpretation of the key attributes of CSR and ESG. Iain will then deal with the middle part of our presentation, dealing with the financialization of ESG, looking at fiduciary duty as an enabler and stewardship as an accelerator. I will then finish off our presentation by explaining or giving you a bit of background and information on our proposed entity model of ESG investing. Okay, so if we start by looking at how we define sustainability, CSR, and ESG, you will see the diagram on that slide. While corporate social responsibility, or CSR, had been the dominant paradigm through which the social responsibility of business was framed over time, the pattern changed with the approach of the millennium. Sustainability emerged as a key concern, and with it, the proposition that investors should incorporate ESG factors into portfolio construction. The financial model of ESG investing is now the standard approach around the world and is reflected in ESG metrics, ratings, guidance, and regulatory rules. It focuses on the role of capital and investors in driving change in sustainability practices and pays less attention to the role of board decision-making and directors' fiduciary duties. In recent years, sustainability, CSR, and ESG have coexisted and have often been treated as equivalents by practitioners, standard setters, and academics alike. In our view, however, the apparent similarities conceal some fundamental differences. Viewed in terms of their fundamentals, the three approaches are quite different. In line with other commentators, we see sustainability as the overarching concept, as illustrated on the slide, with CSR and ESG as subsets that operate within the corporate or entity and financial domains, respectively. Sustainability is focused more explicitly on externalities and, from a corporate governance perspective, on how the de facto norm of shareholder primacy has limited the internalization of externalities through a focus on shareholder interests. The ethical foundation of CSR means in principle that the focus is on doing the right thing in the context of the operational setting of the business. ESG is focused on financial risk and return, and therefore integration of ESG factors into the investment process has the primary purpose of improving returns over the long term by mitigating the risks associated with those ESG factors. So put another way, it could be said, and this will be shown on the next slide, that the three approaches represents a trilemma in the sense that they could not be simultaneously a full implementation of all three. Sustainability, as the overarching concept, could be effectively combined with one of CSR or ESG, but not simultaneously with both. So then to move on sort of to the timeline or the development of these concepts. Elements of the substantive concerns addressed by CSR can be traced back quite far in history. However, it was in the 1930s that CSR in its modern sense began to evolve as ownership diffusion broke the link between ownership and management and focused attention more closely on the purpose for which companies should be managed. Moving forward, the 1980s saw a clearer focus on sustainable development and its links to institutional and legal change. The focus on externalities also linked sustainability more explicitly to mainstream economic thinking than had been the case with CSR, which struggled to gain traction against influential notions of the nature and purpose of the corporate entity. The 1990s saw the emergence of ESG as a portfolio risk management concept linked to financial performance. ESG investing is based on the presumption that its constituent factors are material for the risk and return profile of financial investments. The move to ESG marked a clear shift away from the earlier model of CSR, where the focus was at the entity level and on the impact of corporate activities on the real world. So we see the key attributes of CSR and ESG as follows, and that is listed on the slide. And we really looked at this with respect to specific aspects, focusing on focus, channel, implementation, metrics, and reporting. So when we talk about CSR, the focus is on ethical responsibility and accountability. But with ESG, it is portfolio risk and return linked to metrics, benchmarks, and indices. CSR goes through the channel of corporate entities, where ESG, it is institutional investors and the investment chain. Implementation with CSR is through board decision-making, and with ESG through the integration into portfolio selection and engagement. CSR, we don't really see a specific set of metrics, but with ESG, there's of course multiple with different custodians, scope and legal effect, but limited verification. And then ratings add another layer of complexity here. And then finally, with regards to reporting, CSR mainly through non-financial reporting, ESG mainly through the 5 sustainability frameworks like the CVP and so on. Okay, I will now hand over to Ian to deal with the financialization from CSR to ESG. Thank you.
So I'm going to try to outline and rationalize the key influences through which ESG became financialized. And to do that, I'm going to focus, as in the paper, on asymmetry in fiduciary duties, the 2 types of fiduciary duty that are operating in this space. The role of legal uncertainty in both aspects of fiduciary duty. And then to round up with a view on the role of stewardship as an accelerator of ESG. And of course, stewardship being directly linked to fiduciary duty of intermediaries in the investment chain. So linking up with what Irene-Marie has talked about in terms of the evolution of ESG, we can say that the emergence and evolution of ESG shifted the focus from the corporate channel, which had been the case for CSR, to the financial or investment channel in the case of ESG. And looking first at the corporate channel, that had focused on the operational aspects of corporate entities. CSR had developed in this way with the focus on the business model rather than on the sources and techniques of financing. Secondly, with regard to stakeholders were seen as the key focus in CSR integration. And that approach, while it gave a key role to stakeholders, included also an element of accountability to shareholders, but within the context that CSR issues were viewed as a matter of board discretion and responsibility, and integrated with other issues for which the board would be accountable to shareholders. So we could say generally strategy, financial performance, remuneration, the whole range of accountability linked issues. Now, the shift to the financial channel for ESG changed the focus somewhat. So we see the focus shifting to the supply of capital, especially new capital, because new capital could be more easily aligned to ESG related activities. Whereas in the case of what we might call committed capital, engagement became the key focal point to try to change what the uses to which committed capital might be devoted. And of course, that engagement is clearly linked with stewardship and the development of stewardship codes. Now, sitting alongside that, of course, we have a range of developments and regulatory interventions that are related to financial products, particularly those generated in the asset management business. So that is focused on disclosure of sustainability characteristics linked to the development of new products. And of course, the context in which all this is occurring is one in which we see very rapid growth in ESG funds. So for example, in the first quarter of this year in the EU, funds flow into ESG funds exceeded conventional funds for the first time. So that actually we begin to observe a new paradigm where ESG is becoming the conventional rather than the alternative paradigm for many investors, including retail investors. So the question then is, why did this shift occur? And what were the drivers? Now, we see fiduciary duty as one of the main factors, and so we move on to consider that in a little bit more detail. So, picking up on the reference I made at the outset to asymmetry in fiduciary duty, we can refer to the two forms of fiduciary duty that operate to control the extent to which corporate strategy and operations could focus on CSR or ESG related outcomes. And the first is the duty owed by directors to the company and in some instances to shareholders. So in other words, the corporate fiduciary duty. The second on the left is the duty owed by institutional investors to their underlying investors, which we term intermediary fiduciary duty. Now, it could well be argued that in an ideal world, both forms of fiduciary duty would be aligned so as to reflect the underlying logic that they serve the same purpose. But in our view, that perspective understates two key issues. Firstly, the role of financial return is calibrated differently in each form of fiduciary duty. And that remains true even if it is recognized that the law in key jurisdictions does not prioritize financial return to the extent that was often believed to be the case in the past. Secondly, stakeholders do not feature in intermediary fiduciary duty, whereas they do feature in corporate fiduciary duty, either explicitly, for example, in the Section 172 of the UK's Companies Act, or implicitly as part of the discretion available to directors in running the company. Thus, the different focus of the two forms of fiduciary duty means that they work in different ways and are likely to have different outcomes. Intermediary fiduciary duty, absent contractual modification, as occurs, for example, in ESG funds, would likely drive capital flows with a more explicit focus on financial return than might be envisaged by directors in the lawful exercise of their discretion. In that sense, the flow of capital would not be aligned with governance, and nor necessarily would the operation of capital markets and the links to retail investors. Now, moving from the asymmetry in the two forms of fiduciary duty to deal with legal uncertainty, we could say to start with that legal uncertainty is endemic, and there are a range of mitigation and risk transfer techniques that attempt to limit its impact in the commercial world. In the context of ESG, the risk is that ESG actions would be open to challenge by either shareholders or underlying investors, respectively, on the basis that the action was in breach of fiduciary duty. Legal uncertainty would likely affect both corporate and intermediary fiduciary duty. And so the presence of such uncertainty might suggest that neither would be better placed than the other from the perspective of legal risk as a conduit for developing ESG. However, three factors suggest different effects from legal uncertainty across the corporate and intermediary channels. Firstly, is the issue of ownership structure and individual versus collective action. In widely dispersed ownership systems such as the UK and the US, individual investors could not effectively influence boards to ESG actions without collaboration. Even if that were legally possible, and it wouldn't always be, it would be more costly and less effective than ESG portfolio techniques undertaken unilaterally in-house, we might say. Second, mitigation of legal uncertainty through opinions and standards. While some academic opinions supported an interpretation of corporate fiduciary duty that would enable boards to adopt an ESG approach, they tended to be minority views and were not backed by influential legal opinions or powerful NGOs. The opposite was the case for the financialized model and intermediary fiduciary duty, which was supported at an early stage by an influential legal opinion, Freshfields report, and standards, particularly the PRI principles for responsible investment, endorsed by the UNEP Financial Initiative, the United Nations Environment Programme Financial Initiative. And finally, data had quite an important role to play, we think. The accumulation of evidence on the financial performance of ESG strategies lent credibility to the financial model of ESG, whereas there was no comparable data to support operational activities undertaken by companies through CSR initiatives. In that sense, the available evidence supported the financial model, although we do note in the paper that that evidence of outperformance is questioned in some quarters, and there's some interesting research becoming available in connection with that. Thus, we take the view that legal uncertainty posed less risk to a financial model of ESG than it did to an entity model. Viewed in those terms, investors were better placed to develop the financial model than directors were to develop an entity model of ESG that might have more closely resembled the model of CSR from which ESG emerged. But that high-level perspective glosses over the nature and extent of legal uncertainty in the respective domains, and so it is to that issue that I now turn briefly. The key issue for corporate fiduciary duty, or the key issues, have been whether corporate purpose encompasses objectives other than profit maximization, and if so, how? How interests other than those of shareholders can legitimately be considered in board decision-making. Now, turning first to the issue of corporate purpose, we note that both in the US and the UK, purpose tends not to be defined explicitly in either corporate law or constitutional documents. Thus, the default position in both jurisdictions is that it falls to the board of directors to determine corporate purpose. While in principle, that would open up considerable scope for directors to pursue CSR activities, the emergence of a de facto norm of shareholder value maximization largely constrained any inclination on the part of boards to act in that way. Our analysis, which is set out in more detail in the paper, demonstrates a significant degree of legal uncertainty as to the nature and implications of corporate fiduciary duty, both in academic discourse on corporate law and its interpretation by the courts. Our focus is on observing uncertainty and evaluating its impact, rather than taking a view on which interpretation of corporate fiduciary duty is correct or should prevail. And then moving to legal uncertainty in the intermediary form of fiduciary duty. In the investment chain in both the UK and the US, fiduciary duty was conventionally understood as focused on financial return. That approach was supported by the Law Commission's 2014 report, the influential investor-led body ICJN, and the UK Stewardship Code. The conventional approach was challenged by the Freshfields report in 2005. Its conclusion was essentially that it was permissible for a fiduciary to incorporate ESG factors into investment decision-making in both the US and the UK, albeit that financial return would normally remain the overriding objective. While the progressive Freshfield stance gained traction in the soft law space, in which guidance such as the PRI principles operate, it was less influential for the operation of hard law. More recently, the progressive stance is reflected in the evolving EU regulatory framework, albeit that it is focused more on disclosure rather than explicit articulation of fiduciary duty. Over time, the US has lagged the EU and the UK in the development of ESG and the associated interpretation of progressive fiduciary duty. That trend is evident also in the relatively slower growth of the market for ESG funds by comparison with the EU. But there are now signs of change in the US, with the recent non-enforcement announcement from the Department of Labor being a significant development for the capacity of trustees and asset managers to adopt the more progressive approach. And finally, rounding up this segment with a comment on the role of stewardship as an accelerator, as we see it, of ESG. And we see two ways really in which this process of acceleration has occurred. First is around the alignment of stewardship to shareholder primacy. And as noted earlier, stakeholder interests are largely marginalized by stewardship codes, as the focus of those codes is on the relationship of asset manager and underlying investors. And when we look in that issue in a more granular sense, if we look, for example, at the UK Stewardship Code, it frames sustainability by reference to long-term value for investors, and there is no explicit role for stakeholders within that framing. And the second form of linkage is through the connection of stewardship obligations with fiduciary duty in the investment chain, which is interpreted as stewardship codes supporting an ESG orientation. And we note in the paper that that linkage in stewardship codes is a global trend with variations in the strength of the linkage. And in terms of strength, South Africa and Australia seem to state that linkage most strongly, whereas surprisingly, the UK is weaker in the most recent version of the code than it had been in the original 2010 code. But even so, we would argue that there is an emerging soft law role for codes generally around the world in supporting ESG as an articulation of fiduciary duty. And in that sense, we see the general trend as one of stewardship codes really supporting the financialization process, which was really already in track by the time stewardship codes began to develop and become a significant factor for investor practice. So in the final segment, Irene-Marie will now outline what we see as the key elements of our proposed entity model, which would reverse the trend towards financialization and return to something that is more analogous to the older CSR model, which had been more dominant prior to the emergence of ESG.
Thank you. Yes, I would, for the next part of, or the last part of the presentation, look at our proposed entity model of ESG, and I would explain this by way of a table and a diagram on the next two slides. And I would do this by reference to the same points that I listed before when we looked at the main or the key attributes of CSR and ESG. In other words, looking at or doing this with reference to focus, channel, implementation, and metrics and reporting. Okay, so you would be glad to know that we will not try to go through that slide in detail during this presentation. This is really just a summary, and this is obviously dealt with in the full paper as well. But it really shows you in the first column the sort of the financial way of dealing with this, and with reference to focus, channel, and so forth. Then the adjustment mechanism getting us to our proposed entity model. And I will then use the next slide to try to explain that. So we sketch a full version of the entity model in the table in the paper, and so focus here and during today's presentation will really be on three key issues. I would deal with stakeholders, due diligence, and scope. But maybe just before I do that, just with reference to that slide, you will see our proposed entity model focusing on the corporate channel, as we've explained already, being a hybrid model where we suggest reform through hard law, soft law, but also voluntary action, focusing mainly on process on the one hand and substance on the other hand. When we talk about process, thinking here about due diligence and obligations, potential stakeholder board committees and reporting and disclosure, and substance and linking it to directors' duties during decision making, the link with remuneration and say-on and purpose provisions. So firstly, with regards to stakeholders, our proposed entity model would change the focus of ESG investing to focus more on stakeholders. That would occur primarily through the introduction of a duty of due diligence, supported by a stakeholder board committee. And details on this stakeholder board committee is also provided for in the paper with regards to who do they report to, composition of the committee, applicable to which types of companies, and so on. We view the focus on stakeholder empowerment primarily as a mechanism to drive internalization of externalities. With regards to due diligence, such a duty can be framed as a business process, in other words, a procedural requirement, or a standard of conduct where the focus is on discharging obligations that go beyond internal process, or some combination of both. This provides a more focused and precise alternative to adjustment of directors' duties to encompass sustainability, which might well be frustrated by pressures such as the established norm of shareholder primacy. The EU's recent study on sustainable corporate governance proposed a due diligence obligation, and it seems likely that this will be included in a legislative proposal by the middle of this year. Then on the scope, the entity model of ESG would broaden the scope of ESG, as in principle, all companies and all types of external finance would be covered. In contrast, the legislative framework in the EU has to date been narrower in scope, as it follows the financial model of ESG by focusing on various forms of asset management. The most obvious and substantial emission is bank loans, which represent a substantial element of EU and UK corporate funding, especially in the case of small and medium enterprises. Unlisted companies also represent a substantial gap that could be resolved by an entity model. So therefore then, to conclude, today we looked at the evolution of ESG, looking at the fundamental differences between CSR, ESG, and sustainability, seeing sustainability as the overarching concept with CSR and ESG sort of underneath sustainability, and that both cannot be present at the same time. But we then also looked at the sort of horizontal development as sort of a timeline of CSR moving on to ESG and sustainability. Iain then focused on the instrumental role of fiduciary duty in setting the legal framework of CSR and ESG, looking at the asymmetry that necessitated a choice between two different approaches, and that legal uncertainty favored a financial model of ESG. I then concluded our presentation today with our proposed hybrid model of ESG, entity model of ESG, and looking at potential legal reform, dividing it into process and substance. And during the presentation, the focus was on stakeholders, due diligence, and scope, but more details regarding the model is provided in the paper. So I thank you so much for your time, and we would love to take any questions. Thank you.
Yes, thanks very much, Irene-Marie and Ian, for this very, very clear presentation, which should give a lot of food for thought and also food for discussion. Before we open it up, I want to hand over to Stefan as our first discussant, then followed by Eva. Stefan, do you have a PowerPoint presentation you want to share?
I do not. I do not.
Okay, yeah, no worries.
All right.
The floor is yours. Thank you.
Thank you. Well, good morning, or I should say good afternoon, everyone. First of all, thank you, Carsten, as well as Mark and Edmund, for inviting me to speak today, and many thanks to UCL and LSE for hosting this truly splendid seminar series. And thank you, Irene-Marie and Ian, for your paper. I enjoyed reading it, and I believe that it'll make a substantial contribution to the growing literature at the intersection of CSR, ESG, governance, and regulation. I also think that this paper offers important operational and strategic insights that would be of interest and relevance to counterparts in management, business ethics, and finance. And I hope that you have the opportunity to engage with those researchers and literatures as well going forward. So in the time I have, I'd like to address three perspectives that came to mind after reading Irene-Marie and Ian's paper, which I'll call definitional, conceptual, and instrumental questions. So while these questions address overlapping issues, actually, I find them to be a useful heuristic for thinking about CSR and ESG. And I have my own observations, but also questions for the authors, some of which I hope we'll get to during the Q&A discussion. So first, let me start with definitions. The paper raises, in my mind, definitional questions about the content and scope of CSR and ESG. And in fact, one of its contributions is to simply highlight how broad and contestable those terms are. And as a very brief aside, I think it also implies the same for sustainability and suggests a need for researchers to interrogate the varying applications of sustainability. Now, of course, central to the paper's thesis is that the asymmetry between corporate fiduciary duty and what they refer to as intermediary fiduciary duty enables investors to influence corporate conduct more easily than board directors and the like. Now, based in the States, I particularly appreciated the context on the various principles and standards-based efforts to clarify these duties in the UK, which, while far more advanced in some ways, also implicate somewhat distinct concerns. In that vein, I wonder if the legal uncertainty that Irene-Marie and Ian address concerning CSR is in part due to the nature of stakeholdership itself and the fact that the demands of different stakeholders are by nature more heterogeneous than that of investors. And that's, of course, a contestable proposition, but one, if I may, that I proffer. So I'm curious if Ian and Irene-Marie, what you think of ongoing regulatory efforts in the UK and in the US and elsewhere to clarify the objectives and requirements for CSR, such as, for example, various forms of legally mandated CSR and social enterprise forms such as the Benefit Corporation in the US and CAKES in the UK. And I ask in part as a definitional question to suggest that perhaps CSR is not so moribund after all, and that in fact, there may be ways to draw on sort of existing regulatory and governance soft law-based reforms with respect to CSR in contemplation of your ESG entity model. The second definitional question I have concerns the various conceptual dimensions of the paper, and specifically the questions embedded in the paper regarding the ways that law can be used to promote socially aware conduct, and really, I should say, also the limitations thereof. So section 2.1 of the paper narrates a shift from CSR to ESG. And the paper refers to, quote, the business case for CSR. To me, this brings to mind the influential management research of Porter and Kramer some 10 years ago, which was premised, as I'm sure many of you know, on the ability of firms to create social value by capturing its economic gains through firm-level innovation. Interestingly, as management and business ethics scholars have noted, Porter and Kramer's CSV model is essentially agnostic when it comes to law. It basically ignores it. So a question for the authors is, in the shift to ESG that you described in the paper, I wonder if there are any residual effects from CSR. It's hard for me to imagine that, in fact, if there was a shift, and that shift was in part conscious on the part of firms and investors, that the predominance of CSR as a means to address negative externalities left no mark on ESG whatsoever. And I'm curious if, in fact, that's something you've contemplated. There's another conceptual issue, which is a question that I have about whether the shift to ESG can be explained by factors that are exogenous to law, or rather, alternatively, whether there are non-legal factors that correlate with legal uncertainty. And I note that in section 3.1 of the paper astutely observes there are, in fact, several broader influences that explain the shift from CSR to ESG. And the paper identifies power imbalances between shareholders and boards, and the ability of ESG to overcome or to disregard those power imbalances, differences or perceived differences between firm-specific social impacts and industry-wide or macroeconomic risks, such as climate change, and also the desire of asset managers to justify their active investing strategies, their fees, to their clients by scaling up through the use of ESG. I would add, speculatively, I must admit, several other factors that perhaps come into play. One is, over the last few years in particular, various supply-side innovations and growth in ESG markets. And I would look at, for example, the use of various ESG funds, green bonds, and other socially themed fixed income instruments and the like, to demonstrate that in fact, the ESG market has not remained static, and that innovation has helped drive that growth. There also, I think, is an important factor concerning the relative size of debt markets and the relative size, if not influence, of bondholders relative to shareholders. And there is some empirical research that has sought to address this question, but I think it's, at least conceptually speaking, worth thinking about. And then finally, there may be broader economic, political, and social factors that have dictated this shift. And I think the authors have demonstrated they're well aware of these factors, such as the financialization of the corporate form generally, and changes in the risk profiles and the risk appetite of both firms and investors. And this is particularly prevalent in the UK and the US. And you can think of the ESG movement, if you will, as a response to those trends. Lastly, I'll just end this second discussion of concepts and conceptual questions by asking, well, if these non-legal factors matter, if in fact they're ones that either are exogenous to or correlate with legal uncertainty, that might actually affect the manner in which the author's ESG entity model may be implemented. So for example, if the shift to ESG reflects an underlying power balance between investors and other stakeholders, one that is not necessarily explained by the different treatment of fiduciary duties, then the ways in which the entity model will be implemented within the firm itself may be influenced. And so let me just conclude by very briefly addressing the instrumental questions that arise from the author's proposal. First, with respect to the stakeholder board committee, I think there's a question about the capacity of boards to assess and weigh negative externalities attributable to the firm. So to me, this requires not only oversight, but constant evaluation by the committee about how the firm should define sustainability. And so there are a whole range of different questions that the stakeholder committee would have to address, such as how would the committee determine the appropriate time horizons for different stakeholder interests and demands? How would the committee prioritize investments in so-called G issues, such as gender equity, with so-called E and S issues? How would the committee consider investments in sustainability enhancing innovation, such as, for example, carbon capture techniques, relative to the need for the firm to mitigate its own negative externalities on a short-term basis? If we care about sustainability outcomes, which of course I think we all do, then this latter role of weighing and evaluating actually matters a lot. And I think the paper acknowledges this point when it discusses corporate purpose in section 4.2 of the paper. But in the context of the literature, both in law and in cognitive fields, I think it may be useful to consider the use of stakeholder committees in other contexts. So I think the authors are well aware of the use of the Social and Ethics Committee under the King Code in South Africa. There's also employee representation or the co-determination in Germany. And there also are various proposals floating out there to incorporate advisory boards in US corporations and benefit corporations. I think if this model is going to hinge around the ability of a committee to serve as a repository for identifying and evaluating negative externalities and responses thereto, then there can be, I think, a discussion in this literature that they're addressing to talk about the use of these committees and the relative limitations of these committees. And lastly, I'll just say with respect to the entity model, that in my view, I think the paper perhaps gives not enough credence to metrics and disclosures. Obviously, as the paper notes, there are ample shortcomings with existing standards-based approaches. But I also wonder if the hardening of the paper's proposed model into regulation could address these shortcomings by incorporating metrics and disclosure frameworks into existing regulatory approaches, thereby addressing some of the consistency enforcement issues that they have identified. And lastly, just wrapping up, I have two prospective forward-looking questions for Irene-Marie and Ian, and I think for the audience, which is first, what is the process by which the governance and soft law-based practices in the ESG entity model become hard law regulation? I found that really tantalizing towards the end of the paper, and there's a broad debate primarily in commercial and financial law, but also I think in management about what hardening looks like and what in fact a hard law-based regime would look like coming from an ESG entity model. And I think that the literatures on hybrid and new governance and transnational regulatory harmonization would be a useful counterpoint and context for that question. And second, I wonder if the authors perceive any concerns about the democratic legitimacy of CSR or ESG. I accept that that's not part of the paper itself, but it is obviously an endemic concern raised by a lot of researchers. And I wonder if the governance tools in the ESG entity model are ones that could be incorporated into it, perhaps could address the legitimacy concerns that have been raised about ESG financialization. And I think in the end, these are questions that can be addressed in responses to this paper and perhaps future work that Irene-Marie and Ian may want to undertake. So I'll close by saying thank you, Irene-Marie and Ian, for this fascinating paper, and I look forward to the discussion.
Thank you very much, Stefan, for these very, very detailed and thoughtful comments. You're going to get a chance to respond in a little while, Irene-Marie and Ian, but if it's okay with you, I'd like to bring in Eva first, and then maybe you can take the comments of the two discussants together. So Eva, please, the floor is yours. Thank you.
Thank you. Thank you very much. Let me without further ado, share my screen. So thank you very much for inviting me to comment on Ian and Irene-Marie's paper, which I enjoyed very much. And I've heard it present today for the second time, and it's a really, really wonderful analysis of an important topic. And my job is to comment on it and find sort of ways of critiquing it. The first, so there's as we have heard, there are three concepts that are discussed: sustainability, CSR, and ESG. And they are characterized as sustainability being an overarching concept focused most explicitly on externalities, and also analyzing how shareholder primacy limits the internalization of externalities. CSR then is an obligation of the company to follow independent ethical and social goals. And ESG then is, and that doesn't quite come out of the paper, but I wonder if it's buried in there. ESG as an obligation of intermediaries to take into account ethical and social factors as risk, and that is a hard obligation. And then ESG as an encouragement of investors to use their financial muscle to do good. And I'll come back to that distinction a little later. The first question I have is about the trilemma. And I say this because I wasn't quite clear of what sustainability really was and added to this distinction between CSR and ESG. So in particular, I wasn't clear, is this more than a label for CSR and ESG, for different articulations of the same thing? Or is this a term that refers to a broader societal debate of which CSR and ESG are subfields? And if that's the case, I wasn't quite sure what sustainability added to the analysis of CSR and ESG. So I wasn't quite sure where the try in the lemma came from. Then analyzing CSR and ESG, the paper stands on the observation that ESG is an impoverished, financialized version of CSR. And my question is this really true? And the reason I say this is because where we used to be, say 20 years ago, was there were two worlds of scholarship. There was on the one hand, the CSR scholars, and I have sort of in brackets here called them tree huggers. So those were people that cared about corporate social responsibility, and they did this in their own world. And then there was on the other hand, financial scholars, and they were into maximizing profits and they loved equations. And there was no dialogue between them. These were different worlds that, and so much so that you didn't visit each other's conferences. Those were very separate discourses. And you can also see this at the broader level in society. Now, what ESG has done, it has bridged the gap. And now even profit maximizing equation lovers discuss ecological and social factors. And you could say that ESG is a success story of CSR because the ideas of ESG have now been incorporated into a world where they didn't exist before. And then it's not an impoverished, it's of course a smaller focus, but perhaps to a great credit to the people who originally discussed CSR, that this discussion has now moved on into also the financial space. And in that sense, it's maybe not impoverished at all, because maybe financial muscle is something that CSR benefits from, admittedly only insofar as CSR is financially quantifiable as risk, but at least to that extent. So the question then is, has ESG moved CSR into the mainstream? And in that sense, is it right to characterize this as impoverished? A further comment is the discussion of the de facto norm of shareholder primacy. And that, of course, characterizes the academic and societal discourse that began in the late 1970s and then found its way into the Cadbury Code and descendants. And yes, Section 172 prioritizes shareholders over stakeholders, but I'm wondering, and that's something I've been wondering for some time, is this all not just a storm in a teacup? And I say this because 172 is a duty owed to the company. The directors need to promote the success of the company. The duty is subjective, and there's no requirement to maximize anything. So, and enforcement is procedurally unlikely. So this idea of shareholder value being in any way reflected in the law, I think is an overstatement of what we find. And that is also, and we see this as evidence because no legal change is necessary when our discourse changes to the UK Corporate Governance Code 2016, 2018, the Business Roundtable Statement, and Colin Mayer's British Academy Project. And that was a very clear shift from a shareholder primacy to a more stakeholder-oriented model. But the law itself didn't require any changes, precisely because it never really embodied the shareholder primacy model. So I'm wondering what's really going on is what is identified in the paper, this asymmetry of fiduciary duties. And I'm not quite sure I'm happy with the term asymmetry, but I'm very happy with the observation that these are different things. So directors' duties do something very different from intermediary duties. And they are maybe not even connected. They are, of course, so in particular, so for example, intermediary duties can be modified through contract law, which directors' duties cannot to the same extent. But also one duty is about enhancing return, and the other duty is about owed to the company and promoting the success of that company. And those are different things. And I'm wondering if what is underlying this ESG debate isn't something that has to do more with the institutionalization of investment. So that shift a long time ago now from individuals owning shares to institutional investors owning shares. And maybe that is the source of the shareholder primacy model. And that's because the institutions need to show that they have delivered return to their investors. And that then creates this motor that enhances the shareholder primacy model. And then maybe ESG is a way of paring this back. And then we come to the observation that ecological and social factors are risk factors, which have to be taken into account. And then on top of that, the question of should financial muscle be used to do something good? Now, coming to the entity model of ESG investing, the aim is to focus more on stakeholders. The ingredients of the model, as we have seen, is a due diligence duty of the directors, either as a standard or as a process, is an institutionalization of stakeholder interests through board committees. Remuneration should integrate sustainability. There should be new procedures on enforcement, although the paper doesn't flesh them out. Then there is a suggestion that the use of metrics will help enforcement. Then there is a question of whether there should be public enforcement. To that, I note that the Company Directors Disqualification Act, Schedule 1, Paragraph 1, and also Paragraph 6 already incorporate or have public enforcement for directors who are responsible for the causes of any material contravention by the company of any applicable legislative or other requirement. So that would be something that you can build on because that can lead to disqualification. Another ingredient is corporate purpose. And then the UK Corporate Governance Code 2018, Provision 5, which is the employee representation provision and non-financial reporting. So what we see here is a sort of cornerstones on which sort of characterize the entity model of ESG investing. Now, my comments on that are, I wasn't quite sure to what extent metrics, which are used in the context of remuneration, but also for enforcement, help. And I'm in particular wondering, don't they reintroduce a financial model through the back door? Doesn't that bring us back to exactly where CSR left ESG, or rather ESG left CSR? And is it not the case that the moment we need to quantify, we begin asking ourselves about maximizing things, and then it becomes maximizing in whose interest, and then immediately we are on a shareholder focused agenda. So I'm wondering how that problem can be avoided. And then my other question is, how would a standard of care help? And I say this because if you introduce a standard of care, would you not then also have to remove the subjective standard? And then important follow-on question, how would you persuade the courts to review directorial decisions, which the courts have so far very robustly declined to do? So those are my thoughts and my comments on the paper.
Thank you very much, Eva. Irene-Marie and Ian, do you want to take a couple minutes to respond to the comments of the two discussants?
Yes.
So,
Yeah, are you going to go first?
No, you go ahead if you want.
Well, that's easy then. I can answer the ones I have the answers to, and you can do the rest.
Well, I've got a long list where I don't have answers that I'm going to attempt, but I'll try and keep it fairly brief.
Firstly, thank you for the feedback. It's always really very nice to get such detailed feedback when you've written a paper and you worked on it for a long time, and to get feedback, it's always a really great bonus. So maybe I'm definitely not going to respond to everything that's been said by Stefan and Eva, but maybe just to give some of my ideas and thoughts on some of the aspects or issues that they touched upon. And yes, so maybe to start with Stefan's reply then, I think one thing that you mentioned that I find very interesting is when you talked about sort of the definition part of your reply, you talked about the objectives for CSR, and if you want to clarify how you define CSR, is that perhaps something that you can do through regulatory initiatives? And I think that is a really good point. That obviously you don't want to put a definition in the Companies Act on CSR means the following, but I think if you look at the provision in legislation like the Companies Act on directors' duties and what directors need to take into account, that is already quite a good starting point to try to define what you mean with CSR. But I think soft law is really where you can have a lot of impact here, and where it can be much clearer what CSR really means and how directors need to take that into account during decision making. And I think if you refer back to the South African King report, it's quite a good example where they actually give a very explicit definition of corporate governance. Now, that's not the same as CSR, but they do define it, and it helps a lot to understand what that really means. And the courts have actually in South Africa as well referred to that code and breach of potential duties because of that. And the courts have also starting to play quite a big role in trying to define some of these concepts. So I think that is potential ways to deal with that. A second point then maybe to make is some of the comments you made with regards to the stakeholder board committee. So we actually have a separate paper where we deal with that in a lot of detail, where we discuss the composition of the committee, how it should operate, how it should work, and all of that. And we have done that indeed with reference quite a bit to the South African Social and Ethics Committee that you refer to as well. I think it is in principle a very good idea to have such a committee in place, but we are very much aware of the problems with such a committee. For instance, it is quite the things that such a committee will have to deal with, address. It's a very long list of things. It's very broad. They basically have to deal with any non-financial issue. Who should actually appoint this committee is another issue to consider. Do you see this as a board committee? In other words, they're appointed by the board. In some jurisdictions, board committee members are actually subject to the same duties as directors. That is another thing to consider. Or do you see them as sort of a separate organ in a sense of the company? When they report back to the shareholders, how will that work? Because the shareholders do not have fiduciary duties to the company. So there's a lot of issues there. But in principle, we think it is a potential solution or a potential way to deal with stakeholder interests. But if you follow a different approach similar to Provision 5 in the UK through soft law, that is another way to sort of get the same result that you would get with such a committee. So, provided that it works. And we have indeed done some research on Provision 5 and whether it's working or not, even on a comply or explain basis. And it seems that companies are adhering to that, although it's very much the feedback that they give on Provision 5 is very much, we have this and this in place, but they don't really tell you how they will take the interests of stakeholders further. So for us, it's not just for directors to recognize stakeholders to try to protect them. It is really to get them engaged in the decision making, and the mechanism or the tool that one opts for then really has to try to deal with that. So that's really my main comments with regards to Stefan's paper. Ian, I don't know if you want to deal with these, and then we can maybe turn to Eva's after that. Or do you want me just to continue?
Maybe I'll go to the chair on that one.
Why don't you just continue, Irene-Marie?
All right. So thank you, Eva, then for your comments. Your one comment is very interesting, and I think it actually sort of supports our point, or how difficult it is to define ESG, CSR, and sustainability. And that's the point that you made with regards to sustainability and where does it really fit in. I think that's a really good question. I mean, where does it really fit in? It's, if you look at the literature, the way people's referring to it, it's often they talk about sustainability, but they will often actually refer to ESG, or they will often even refer to CSR. It's sort of, and that's why we use the term overarching concept, because we see it as sort of the the broad concept for all of this, with ESG and CSR then under it, and the focus of sustainability much more on the economic side of things. So that's maybe the first thing that I wanted to say. Then you talked about CSR versus ESG, and especially ESG as being impoverished. I think, yes, the comments you've made there are true, but I think with ESG, for us, the ultimate outcome is just so much different. With both CSR and ESG, they need to be that during decision-making, corporate decision-making, or through investment decisions. They need to focus the directors and the investors on sustainability, on non-financial issues, on ESG factors. But the ultimate outcome is different. With ESG, it is still the risk and the return and the ultimate, making of a profit, where for us, CSR is different. So maybe ESG has helped in a sense, but it is still two very different concepts. And like you said, in the end as well, for us, the focus is very much on stakeholders. Then you also talked about de facto norm of shareholder primacy, and you referred to Section 172. So we are indeed not proposing any specific reform to Section 172. We rather see stakeholders getting better protection, and not just considering their concerns, but to get them actually engaged during decision making through the other ways or mechanisms that we refer to in our paper, and specifically soft law, hard law, due diligence, and all of those aspects. I think the one aspect maybe just also to mention is the role of metrics. I don't think our point is that metrics, it's not a good thing, that you shouldn't use it. I think it's sort of absent in a sense from the CSR sort of track. And if you can get better metric systems and you can actually use that, that will also help, especially with regards to due diligence, and the point you made with regards to the subjective standard. If you have a set of objective metrics in the context of CSR rather than ESG, and you can even use some of the metrics that's been developed in the ESG sphere already, that can help you to actually exercise your duty of care with reference to that metrics, and that can again feed back into the due diligence obligation that we are proposing. Okay, that sounded like quite a lot. I hope I dealt with at least, 80% of the question, but I'll hand over to Ian at this point. Thank you so much.
So let me just pick up on a couple of things to be brief. So I think firstly, Stefan, your point about the diversity of stakeholder interests and its the impact that it has on the the integration of their interests in the ESG model and the link to ongoing regulatory developments. So I think you're absolutely right that, you know, clearly there's a diversity in the nature of stakeholder interests and their capacity to be involved in decision making. But my take on it is that, you know, that issue has been largely sidestepped in the transition to ESG because really stakeholders don't have an explicit role in the ESG model, and that is reflected to some extent in the prioritization of disclosure in the regulatory dimension of ESG, where the disclosure is in the main aimed at investors, although, for example, within the EU framework, the non-financial reporting framework, there is some semblance of disclosure for the purposes of stakeholders. I think that's linked to also to the point, the excellent point that you made about, you know, what is the residue from CSR that we observe in the ESG model. And I think for me, the kind of elimination of the stakeholder dimension means that there is not really much residue left. And, you know, the way that I would sort of explain that is to say that, you know, what we saw really was sustainability provided a kind of pivot from, you know, that enabled ESG to, if you like, reorient the old CSR agenda. But the reorientation really took effect without directly addressing the externalities dimension in sustainability. So, you know, ESG has managed to own sustainability without really resolving the externalities aspect very directly. And of course, you know, linking up to the point you made about the sort of democratic accountability and whatever, you know, I think one of the reasons we're seeing so much discussion about the role of corporate governance and financial regulation in sustainability is simply the failure to have proper carbon taxes. And of course, if we had that, we wouldn't be viewing corporate governance and financial regulation as so important as we do. Briefly on a couple of the points that Eva made, and thanks again for some good pointers. I think, Eva, you know, your question, does ESG pare back shareholder primacy? Not really, in my view, and I'm not so convinced that, you know, providing a kind of financial apparatus around CSR is necessarily the way to go. I mean, it may have presented a conduit for taking forward some aspects of the sustainability agenda, but I think ultimately it doesn't really resolve the externalities model. And just concluding very briefly on your point about metrics and your doubts over whether metrics would help with the entity model, I think the way that we see it is that metrics focused on the operational level certainly can be helpful, but having what you might call a double layering of metrics, whereby we have operational metrics and financial level metrics, to me is an unnecessarily complex system. It would be better to really focus on measurement and impact at the operational level. And we see that, for example, in some of the developments, like, you know, the standards that SASB is developing are focused at the operational level, and so too is some of the work of the ICGM, which for me are both welcome sort of movements away from the financialized model of ESG. Thanks also, Eva, for your more specific legal points, which we'll certainly pick up in terms of duty of care and potential enforcement. These are aspects that I think will make it into the final version. Thank you very much.
Thanks very much, Ian and Irene-Marie. Without further ado, I'd like to open it up now to the audience.